Hi everyone, welcome to my seminar. This is Revision Online 2022. I'm Frank Stiegler from Frankfurt, Germany. Most of you probably know me as Netpoet, a demo scene musician for, 20 plus years. And today I'm speaking to you as an IT lawyer and as the owner of a small little company called Inara, at which I do data protection office for a small number of fine companies. Today, I would like to cover a data protection topic that I'm sure concerns you, that has caused a lot of rumpus, discussion, frustration even, I would think. And I would like to shed some light on this. And again, I'm sure it will concern you regardless of whether you've heard the terms that I'll be using in the talk. So just bear with me. You will. Now, there's one thing about the topic that I'd like to mention. Last week on Twitter, I asked a lot of you what you'd like covered in this talk, and most of your answers covered things like how can I use audio samples or other creative works for my own purposes, or how may other people use creative works for their purposes, and so on. How GEMA works, things like that. Now, there is something about this. I have covered more or less all these aspects in the past in, a seminar near you or not so near you in the past 15 years maybe. And I did not want to repeat myself, but I still want to answer your questions. As all these videos are pre-recorded, there is no interaction which we would need. So what I'm trying to do is set up an Ask Me Anything law-related session at Revision. So watch out for that. If you're interested in this session, we can just, discuss your issues. Discuss your issues. You can toss your questions at me and I'll do my best to answer them. And so yeah, keep an eye out for that. There is one term that I'll be using constantly, and I just want to get this out of the way, and that is the term of the controller. Under GDPR terms, and basically everything I'm covering in this talk today will be GDPR related, a controller is a person that gets to decide and decides on what personal information is processed for what purposes, who is the concerned individual or are the individuals, whose data is transmitted to whom or made accessible to anyone, things like that. So the controller is the one to get to decide all this, not necessarily the person that processes the data, which would be the processor. In some cases, it's different. Now, let's get going. My topic for today and for you is called How an Austrian Took Over Europe. Again, kind of history and outlook on the data protection territory dilemma. So you can figure out that it will have to do with what territory is used to process personal data. And this will be a core aspect of why certain things are really frustrating, sometimes very difficult to do. And so what I'd like to do today is cover this, give you an idea of the problems and options of processing personal data outside the EU, lawfully, of course, because if you just wanted to do it and didn't care, you know how to do it probably. So that will be a core issue, like why is it difficult? What can you do? When does it even matter? And things like that. What are your options? All this. Then secondly, what has been previously attempted to solve the problem? And you, as you see the word attempts, you can figure out that it hasn't really worked. Then how is everyone involved dealing with this? Meaning the controllers, the processors, the supervisory authorities. How is everyone dealing with this? Then fourth would be, what is the EU currently trying or allegedly trying to solve the problem? And then lastly, I'll come to a conclusion so that you won't be standing in the rain thinking, oh, Jesus, what the hell? All right, let's go to the first point. Problems and options of processing personal data outside the EU lawfully. We have one key hurdle, and that is in the Articles of 44 of the GDPR and the following ones. We will be discussing 44 through 49 mostly, just so you know. And 44 basically says, and this makes perfect sense, two things: any transfer of personal data under the protection of GDPR outside the EU is only lawful if all the stipulations in that chapter, meaning 44 and the following, are complied with, and it makes perfect sense. The second paragraph that you see here says it too. The level of protection of natural persons guaranteed by this regulation, meaning the GDPR, may not be undermined. Makes perfect sense. Otherwise, why start it? Because you could be processing personal data just outside the EU and you wouldn't have to care. Obviously, that is not the case. And now you can probably see why the territory problem might be real, because if you have legislation for the EU and you say it doesn't matter where you process personal data, if you transmit it somewhere else, then all this applies too. Then that means the EU kind of wants the GDPR to be adhered to even outside the EU, obviously, and I'll come back to that. Now, there are two things important to say. One, if you process personal data for purely personal or household activities, whatever that is, I'll just leave this here for now. So private purposes, the GDPR doesn't apply to you, and what I'm talking about today in the seminar also doesn't apply to you. But to sort of close the bracket on this one, the GDPR has to be applicable whenever personal data is processed, no matter where you are. Also, if you don't have a residence in the Union, actually it is even more problematic if you don't have a residence, because most of the outer EU processors, like the large companies, need a residence, or at least it makes things much more easy to comply with. But so if the GDPR applies to you, it doesn't matter where you reside as a company. So if you've been wondering why or when is this relevant to you, well, basically, if you have some sort of commercial background, there's hardly a way around this being interesting or relevant to you. If a company has any, I don't know, Facebook, Instagram, whatever commercial page, it does. If you want to use Google services such as analytics, maps, fonts, AdWords, or some sort of conversion stuff, it applies to you because the data can be processed outside of the EU. If you want to do hosting with Amazon Web Services or any of the additional services that AWS offers, if you want to use customer relationship management services outside the EU, such as, let's say, Salesforce, a ticketing system, Zendesk or something, provided that it's hosted somewhere else and that you don't have it locally installed. Mobile device management with services such as Jamf or something. All this, and just so that we're clear on this, this applies even if you have a service that resides in the EU but has a subcontractor in like one of these. Like if you have a subcontractor in the US, such as AWS. Let's say you have any service running, but they have AWS hosting in the background. It applies to you too. If you are a controller, if you get to decide what personal data is processed for what purposes. So I couldn't help but give you a little map and to give you an overview of how relevant this is and whenever. So a map of the world. I had to recreate this because I couldn't find one. And if there is a country missing, just don't be patient with, be okay with me. I'm not a graphician. I just had to redo this. So you see the EU, and there's one thing I'd like to mention. And now, there will be a couple of countries that we will be adding to the bad countries, the problematic ones, because there are some good countries. I'll get to that in a minute. But so if you are in one of these displayed countries, like Europe, you're usually okay. Then all this transmission, cross-border processing thing doesn't apply to you. But actually, EU isn't technically correct because There are 3 more countries, meaning Liechtenstein, Norway, and Iceland, that joined the application of the GDPR. And that is, so basically when I say EU in this context, I mean EEA, the European Economic Area. So you have those 3 as well. And then there is a couple of countries that have what the EU Commission has stated as adequate data protection levels, meaning whenever you want to process personal data in one of those countries, then it's not like you don't have to adhere to the principles. You do, but one of the options that you have in order to do that has already been used. So if you want to process personal data in one of these countries, you're good to go, because those countries have adequate data protection levels, and a so-called adequacy decision, according to Article 45 of the GDPR, has been issued by the EU Commission, meaning basically you're okay if you want to process personal data there. Just for information, the last countries to be added to the list last year were Japan and the Republic of Korea and the UK. You remember that? You remember Brexit? So as the UK left the EU, there had to be formal proceedings in order to ensure that if you wanted to, if you process personal data in the UK, you needed some sort of legal basis. It's been made, so the UK are there too. So let's add those countries to the list as well. And there used to be adequacy decisions for the US too. I'll get to that later. But so all other countries that are still blue on this map are kind of problematic to start off with, including the US. And I'm saying this obviously because most of the service providers that companies are using today reside in the US. So what about the US? The US are not on the list, so those are a problem, and we will get to your options, what to do soon. But the US are problematic. I can give you a little outlook on this, because there are some laws that just make it problematic for adequate data protection levels. There are some laws, for example, the FISA, the Foreign Intelligence Surveillance Act of 1978, the U.S. Patriot Act of 2001, hello, 9/11, the U.S. Freedom Act of 2015, and you might have heard of the Clarifying Lawful Overseas Use of Data Act of 2018, probably not under the name, but if you've heard Cloud Act, this is it. So Cloud Act kind of has to do with cloud services, but the name is an acronym, so it's not because of cloud, but because of this bulky little name right there. And I just chose to added a little info here. You might remember Microsoft's attempts to reject the giving access to personal data to U.S. authorities. And I'll just make this quick. You can look this up. It's on Wikipedia, just as many other things I'm referring to here. Between 2013 and 18, Microsoft basically was in a long lawsuit against U.S. authorities, ultimately against the U.S. Department of Justice. And it dealt with extraterritorial access to personal data. There were criminal proceedings, and the authorities demanded demanded from Microsoft to provide access to personal data of a non-US citizen that was stored on an Irish server. And Microsoft rejected, saying, you're not competent for this. I'm not giving you access. So they did what they could. What followed was a year-long, again, 5 years, a year-long lawsuit, that went through several levels of jurisdiction, all the way up to the U.S. Supreme Court, that was planning at the time to decide on this, like ultimately decide and then finally decided for good in mid-2018. And if you followed this a little bit, this might now make sense. The Trump administration passed the Cloud Act that I just referred to in early 2018, and more specifically on the 6th of February. And then the US Supreme Court said, okay, this is moot, meaning it doesn't make sense anymore to decide on this because now a new law has been introduced. I'm not going to decide anymore whether Microsoft would have won against the US Department of Justice because the law has now changed. It doesn't make sense anymore. I don't want to write the long document that decides the case. So back to the laws, you now see that with the Cloud Act, finally, it's basically been pretty much decided. The US want access to personal data. I'm not going to go into any of the details of the US laws, also because that's not my expertise, but just keep in mind that these are just the laws. There are also NSA programs such as PRISM or upstream collection that are also problematic. So you can see there's probably more, and this is only the US. So obviously what I'm talking about might be relevant to you when you go outside the US, like Russia or, I don't know, China or anywhere you want, any other country than the ones that you saw on the map, the ones that are still blue. So I'm just covering the US because most services are in the US, but the principles apply everywhere else. So to round this off, the problem is a GDPR data subject, meaning you and I, if our data is somewhere on a cloud platform, we have rights. We have rights to access, erasure, correction, all sorts of things according to the GDPR. But as you can see, this is going to be problematic if we want to enforce that outside of the EU. Let's say a third country authority, like the criminal authorities in the US, in I think it was New York against Microsoft at the time, demand data on me or you or from any other company under its jurisdiction. So it has to have some sort of affiliation with the US, so or the respective country, so that they have to give data out or give access to. Then the company, the cloud provider, cannot lawfully deny access. And finally, then what? Then you can't go to court. I mean, you could try, but the court will say no, and please go home, and you will go home or go weep somewhere in a corner. Depends. So that is the underlying problem that we will come back to in this talk again and again and again. And it's actually quite fascinating to me, but you'll see this after in the course of this talk. So what options do we have if we want to we as a company or as an organization want to process personal data outside of the EU, for example, in the course of using any Google service or so? Well, we have. Let's assume we want to do that in the US. We could look up an adequacy decision. We could, and I'm now just summarizing this to spare you looking at the actual laws. We could take appropriate safeguards. We will go into detail of all of this in a second. According to Article 46 of the GDPR, we could maybe have binding corporate rules, so-called BCR, according to Article 47. We could use Article 48, strangely headlined by transfers not authorized by EU law. Okay, we'll have a look at that too. And then there are so-called specific situations according to Article 49. Those are our options. Now, the first one we've already crossed off the list. Remember, we checked whether the US were in the list of adequacy decisions according to Article 45. They weren't. So, okay, here goes. So let's have a look at the so-called appropriate safeguards. Article 46 in number 1 says, the transmission, the processing of personal data outside the EU is only lawful if the controller or processor, depending on whom we have, so in our case it might be a processor, if we have Google, for example, has provided appropriate safeguards and enforceable data subject rights and effective legal remedies for data subjects are available. That sounds okay. Maybe the processor, maybe Google can provide our data subjects enforceable rights in the US. Maybe. But so just so you know, this has to be official. So the EU Commission has to have approved those things. If you just do that in your own basement, it might even be that you can pass, but it's unlikely. I would always go for official ones just so that you can rely on them. I mean, and it doesn't make sense at this point, but you will understand in a minute. So the EU has actually passed so-called standard contractual clauses, so-called SCCs, to cover exactly this. So they have passed two decisions of sets of clauses of SCCs that you can use if you want to hire a processor in the US, for example. And there have been two versions. One is from 2001. I'll call those the old SCCs. And one from last year, actually, 2021. And I'll call those the new SCCs. And for now, let's just leave it at that and say, maybe that's something we can use. Fine. But let's check the other options first, because this is kind of difficult, as you'll see. So maybe we can use binding corporate rules. Article 47, number 1 says, the competent supervisory authority shall approve binding corporate rules in accordance with, provided that they basically do what we need. And I'll just abbreviate this here. There are none. None for the regular processing or cloud service provision that you want. There just none exist. There are some mechanisms that allow you to pass them if you want, but I can probably summarize it as it's cumbersome, it's expensive, it takes a long time, and it's not. And just because you spend a lot of money and time on this, it doesn't matter that you are actually granted those rules. And obviously, just because you go through proceedings, you'd still have to make sure that data subjects have enforceable rights and everything. And it's difficult. So there are none, let's just say, not our option. Okay, transfer is not authorized by EU law. We go to Article 48 and look. Okay, and it says any judgment of a court may only be recognized or enforceable in any manner if based on an international agreement without prejudice to other grounds for transfer. So this is a single, like case-by-case thing. If you have a court decision in a different country, could that be enforceable in the EU? Not our case. No. Okay, so last one, specific situations. Let's have a look. And this is a longer one. I summarize this for you again. Article 49, number 1, lists these options. One would be the data subjects, the concerned data subjects, meaning the people whose data you're processing in, let's say, Google Analytics or in your AWS hosting or something, have given their explicit consent after having been informed of possible risks of the transfers due to the absence of an adequacy decision and appropriate safeguards. It's legal babble, but it basically means if the concerned data subjects have given at their free will, let's just assume that something like this exists, consented to you using the service, then you're okay to do it. I'll leave this here for a second because maybe the other options that we have are easier. You could also do that if it's necessary to fulfill a contract with or in the interest of the data subject. So let's say you want to use Google Analytics in order to fulfill a contract with the concerned person. So When can that apply? You go into a contract with someone saying, yes, please process my personal data with Google Analytics, or yes, I want you to host my personal data in the course of your cloud service on Amazon. It doesn't matter. So no. Is it necessary for reasons of public interest? Maybe that would be an option too. Is it necessary in the public interest to use Amazon Web Service? Yeah, no. Is it necessary to exercise or defense of legal claims? No. No, you don't need that. You could do that differently. Is it necessary to protect vital claims? Meaning, do you have to store data on, I don't know, let's say AWS, otherwise people die or get hurt? No, there are other providers. So no. So how about the consent thing? And I can tell you it's a big issue. I know there are attempts to do it, but just for the sake of clarity and ease here, no. Why am I saying this? Even without the international transfer, it's cumbersome. The consent has been called the little a-hole of legal bases for a reason. It is an actual consent, according to the GDPR, is cumbersome to get. It's difficult. It's relatively expensive because you need to create business processes, you need to archive things and everything, and also it is the most unstable legal basis because if it's an actual consent, it has to be withdrawable at any time with effect for the future. So it is also the most uncertain one. So if you wanted to reliably base your use of, let's say, AWS hosting or the use of your Instagram page or something on consent, you couldn't reliably do it because you would always have to filter out the people who have not consented or who have withdrawn consent. I think it's impossible to do. Don't do that. So let's also cross this off. And that basically concludes this chapter, meaning if you want to do cross-border data transfer and processing, the appropriate safeguards that you see here as, we will look at that, is basically your only option today. Let's go on to the next chapter that I beautifully headlined Previously Attempts to Tackle the Problem. Now, I'll give you a little historic overview here in chronological order. So keep in mind that the GDPR has only been in effect since 2016. Before it was the Data Protection Directive, just so you can keep this in mind because some stipulations have changed and that might have changed the requirements too. In 2000, there came to light the so-called International Safe Harbor Privacy Principles. The EU Commission had developed them between 1998 and 2000 and passed an adequacy decision in 2000. You might remember from the previous chapter, adequacy decision according to Article 45. The EU Commission had said, if you, company or organization or whoever, abide by the rules of these principles, then you are given an adequate data protection level, or I deem that whatever you're doing is adequate to protect personal information and the rights and freedoms of the data subjects sufficiently. I'll make it short. The Court of Justice in the EU rendered it invalid in October 2015 because, and I quote, legislation permitting the public authorities to have access on a generalized basis to the content of electronic communications must be regarded as compromising the essence of the fundamental right to respect for private life. And you might remember that Snowden played a vital role in this too, as he revealed a lot of information on the data collected and processed by all sorts of organizations. So, what has been tried to solve this problem that companies want to process personal data in the U.S.? Safe harbor, off the list by 2015. After that came the so-called Privacy Shield. And as you can see, 2016, it was developed in a hurry pretty much. It took, in my experience, a couple of months for this to see the light of day. It was created to replace Safe Harbor because keep in mind or just be aware that by the time the Court of Justice in the EU had invalidated Safe Harbor, a lot of companies using Google services were out of a legal basis. What they did at the time was not lawful, and they were afraid they would be fined or otherwise, face legal consequences. So something had to happen, and the EU Commission knew that. So it was developed, and the EU Commission passed another adequacy decision, again, Article 45. So if you used the Privacy Shield principles, if you submitted yourself under these principles, you were good to go. That happened in July 2016, and it didn't come as a surprise. All major providers submitted themselves to this. So Google, Amazon, Facebook, everyone, like the big companies all submitted themselves to these rules. So at least on paper, you were good to go. And you sometimes read that today still, but you might have noticed that the Privacy Shield has disappeared from a lot of websites, and you'll figure out why in a second. So even when it existed, there was a lot of controversy between the European Data Protection Board and the EU Commission on whether the problems addressed in the invalidating the Safe Harbor decision were solved in Privacy Shield. Basically, data protection experts said, this is just the same, again, with a different name. It's not solving the core issue of what I talked about, that you as a data subject are just not able or not entitled to sue for at least even access to your personal data in the US, for example, let alone other countries, I meant. And then Schrems happened again. And now you have the name that I was referring to, obviously, in the title. Maximilian Schrems is a distinguished and valued colleague in Austria. You might have heard his name. You probably have. The first time I heard the name was when I read an article about a certain Austrian law student. He was a student at the time still, who demanded Facebook access, demanded from Facebook access to all his personal data on Facebook. And that was prior to GDPR. And the legend goes, and Max, if you're watching this, you might give me more details on this so I can tell the story better. The story that I read was that he basically got a box of paper, of printout, because at the time there was no actual standard, and probably Facebook also didn't want to give him his personal data digitally. But that was the first time I read the name, and we will get to his organization later, but at the time he was still a student. But Max Schrems is also one of the involved parties in the first decision that rendered the Safe Harbor principles void or invalidated those. So he had gone to court again. The Court of Justice of the EU passed another ruling in June 2020 that is commonly referred to as the Schrems II ruling. And that did basically two things. It invalidated the Privacy Shield, I could say again. I mean, it was the first time for the Privacy Shield, but it did again what it had done for Safe Harbor. Privacy Shield was basically off the chart. And also, and this will be interesting in a minute, It clarified the lawful use of standard contractual clauses. Remember from last chapter that those are currently our only option to process personal data outside the EU lawfully. So the Court of Justice in the EU did those two things, but mainly it pooped on the party that was the Privacy Shield until then. Well, so what did the court ruling do on the Privacy Shield? It said it doesn't provide adequate safeguards. It didn't really come as a surprise. A lot of people had already assumed it, and it was basically an open secret, but it just said it again. And the reason was that it didn't limit, the Privacy Shield principles didn't actually limit the powers of US authorities to gain access to people worldwide as long as the company that they're requesting access from falls under their US jurisdiction. FISA, Cloud Act, Patriot Act, so on, Freedom Act, the ones that you saw in the first chapter. There used to be a procedure described in Privacy Shield. It was called the Ombudsman mechanism, but it was not binding. So what it said was, well, if you have something on your mind, if you as a data subject want to gain access, you can go to the Ombudsman and they will involve the other party and you will negotiate. But if the other party said no, or there was nothing you could do, or you couldn't enforce it. So the CJEU said that's not enough. Like, if we need something stable, something reliable, if people want to go to court and rightfully get their access to their data, that has to work in the US or in, I don't know, other country, as well as within the EEA. And it's kind of funny because the same was true for Safe Harbor at the time too. So it didn't come as a surprise to us, but maybe to you, maybe to the EU Commission, who knows. And then the second aspect of the Schrems II ruling was on the SCCs. They basically said the current SCCs, and that was in 2020 when still the old one were valid. So at the time it was referring to the old SCCs, are in theory, in principle, viable. So the court did not say, oh, the old SCCs are not okay, but it said it takes appropriate measures, additional supplementary measures. You can't just copy and paste this thing. You have to have additional measures to make sure that personal data is processed lawfully. And remember why the Safe Harbor principles and Privacy Shield couldn't make it or couldn't stand in front of court. It was because data subjects just didn't have access to their data. You couldn't go to court, like not solidly. You could try, but you wouldn't get it. So that was the problem. And now the court said, well, if there are additional measures that are appropriate, then you could use this. The problem at the time was everyone did copy and paste. So nobody cared for additional supplementary measures. Nobody did. So in the status quo at the time, that basically meant, I mean, the court said, well, in principle, you can use it, but in practice, it meant, yeah, but no. So it was all copy and paste. You couldn't use it. It was useless. It wasn't sufficient. So remember, Schrems II came in June 2020. And by September 2021, everyone had basically adapted to the new SCCs. So and what had happened in the meantime? So there are sort of 15 months in between. So what happened in the time in between? The Court of Justice had said old SCCs as they are not okay. And then the EU Commission went and elaborated and created a new set of SCCs that came out in June 2021. So it took pretty much a year to pass this new decision. And then the EU Commission said, well, these are the new principles, the new standard contractual clauses. If you adhere to those, you're good to go. What the EU Commission and these set of rules obviously didn't include were the supplementary measures, because they're a case-by-case thing. The exact thing that the court said you need, you still had to do on your own, but the general framework, the new SCCs had been created, and by September 21, everyone had basically adapted to it. All the big companies had done that. Just so you know, if you ever get to deal with that, if not, just ignore this. The new SCCs were different in the sense that they addressed a couple of issues. They were also modular in the sense that they were different depending on whether you are a controller or a processor. Or if you as a company are a controller and you want to hire a processor, or if you want to work with another controller, or if you are basically, let's say, AWS and you want to have subcontractors, so we would be processor to processor. So you had controller and processor on both sides, and so you had basically 4 different modules. So you couldn't just copy and paste it. You had to find the modules that are applicable to you. And again, supplementary measures are still necessary. Now, let's go back to the attempts so far to solve the problem. We will get back to the new SCCs in a minute. So if you wanted to do that, Privacy Shield was off the chart again. And then so you were left with the SCCs, meaning the new SCCs. So the previous attempts, the attempts so far by the EU to solve the problem, have been pretty futile. Now let's go on to how all the involved parties are dealing with the issue: the controllers, the processors, the authorities. Again, let's go back to what are our options. We might have an adequacy decision. Well, not today, but in the future, maybe. I'll get to that later. And appropriate safeguards, meaning the new SCCs. I said in the previous chapter, currently that's basically your option. New SCCs, if you want to process personal data outside, those are basically your only option. Yeah. So what the European Data Protection Board says that these measures can be. Remember, you have a framework, the new SCCs, that you can take and say, these are my supplementary, my contractual addendum. And now, as the court said, we need additional measures. What can they be? And the European Protection Board is a legal entity in the EU that utters all sorts of opinions, gives you help and download resources on how to work with personal data lawfully. And the European Protection Board says a couple of things about what you can do to process personal data in the course of the new SCCs. And they say, for example, well, you can use encryption. Let's see what that means. You are a company or an association or not just a household activity, and you want to use AWS hosting, for example. What can you do? Well, you could encrypt your data so that AWS cannot access them. When does that make sense? Well, maybe if you basically just want to use AWS as a backup resource. You encrypt you make a backup, you encrypt it, and you upload it to AWS. That would work, but that doesn't make much sense if you want to use traditional hosting, or any other provider that I can think of needs access to your data. Like, let's say Microsoft 365. If you want to use the Office and not just a storage facility, if you want to use the functions of the cloud service, then the service provider needs to be able to access the data because they need to process them. If they can't, then it's a useless service. So encryption, maybe, but yeah, but no. You could pseudonymize things. So you could, for example, use IDs instead of names that don't tell the provider anything about the actual identity of the data subjects. Maybe it's difficult to say. There might be cases where that works, but most of the time you will have users have actual user accounts so that the service provider can access their data. It's unlikely that you can pseudonymize in a way that is sufficient. So questionable. Then the EDPB says, well, it's also okay if you transmit it to a so-called protected person, like, for example, a medical doctor that doesn't have to give authorities access to certain data because of, let's say, client confidentiality or something. Like lawyers might be a case where that works. A traditional service provider, unlikely. And no, like not happening. And they also give us another scenario in which that might work, being you could separate the duties and the access to the data onto several providers in a way so that neither can access personal data on its own. So that if authorities just approach one of them, they cannot give data out without the authorities going to the other one as well. I think that's a very artificial scenario, and I would say useless in most of the cases, but I dug through this EDPB paper just to find scenarios for my clients that might work. And those 4 that I could find are just useless in practice most of the time. If you find a way to do it, I'm all for it. Please go ahead. But most of the time, unlikely. But there are a couple of technical and or organizational measures, meaning TOMs, that I have stumbled upon or stumbled across that I want to share with you as well. And one is the data importer, meaning the person outside the EEA importing my data and processing it, says, well, in case the authority approaches me and wants access to data, I could just inform you. 2 things about that. I mean, it's nice, but 2 things about that. First of all, you might not be allowed to tell me because it's national law that you cannot tell me. So in that case, you wouldn't be allowed to tell me. And secondly, even if I know, what am I supposed to do about it? Then we are at square one. There's nothing I can do to prevent it because I can't go to court. Data subjects cannot. We cannot exercise our rights. Then I would just know. So the knowledge of all this does play a role, but only in a different context, meaning how likely do I have to take additional measures, and like what's the risk involved? And the risk is obviously higher if it happens all the time. If the supervisory authority knows, like mine, the GDPR one, knows that Microsoft is approached each and every day, let's say thousands of times a year, to give access to data, then it's probably, it might be a less qualified data importer than a company that's never been approached. But again, just the fact that I know that data access has been requested doesn't really help me. So then some companies have allegedly created so-called sunset clauses on the no requests received status. You might not be familiar with sunset clauses, but sunset clauses are clauses that run out of validity automatically, that expire automatically. And so, for example, you could find in a contract a clause that says, we have to tell you every, cycle, year, month, whatever you want, that we have not requested any access to personal data, and we have to renew this clause in order for it to be extended. Meaning, it basically means if I, as a data importer, as Google, as Amazon, as whoever, just shut up all of a sudden and don't give you that we have no requests received status anymore, that, just so you know, it means that we have. Yeah, it doesn't help really. It's the same problem, just like reversed, but sure, even if I don't have any information on data access requests anymore, then what? There's still nothing I can do. I could just take my data and go to a different provider. That would shift the problem, but not actually solve it. But I've stumbled across this. Then, and this relates to the first one, sometimes providers give you regular information on the number, kind, and outcomes of data requests that they've received. If possible, naming the requesting authority. So providers can, and sometimes do, give you access to reports on how many requests have we received, what came out of it, what type of data did they want, so that you as a controller can evaluate whether this provider is still good for you to go or not. And another thing I have read at times was some companies, I've read this from Microsoft even at some point, was a clause that Microsoft would go to court for you as a data subject in order to help you exercise your rights. And I'm not sure, as I'm not an expert on US law, I'm not sure how effective that would actually be if the courts are not bound by GDPR purposes or GDPR principles. But I've read it. So some providers will go way out to ensure that they do everything that they can for you to be able to exercise your rights. Sometimes, in very specific cases, the use of so-called hardware security modules, which some of you probably know much better than I do, is also part of the contract. It's basically a key and lock system where the data importer, the processor outside of the EU, can have access only under certain circumstances. So if, let's say, a requesting authority approached the service provider, they might, for example, not be able to access data without your consent, without your pushing the button that it's okay for them to access these data. But in most cases, this is useless in practice. The standard cloud service provider, if you had to press the button all the time, it wouldn't make much sense. So this deals also with this encryption topic that the EDPB mentioned earlier, but it's complicated to do. It's not impossible, but it's not very viable for standard everyday cases. So are all these things acts of goodwill? Sure. But do they actually solve the problem? Maybe not. So what I'm trying to tell you is the attempts that the concerned people, the controllers, the processors, the data exporters, importers, are the attempts that they're undertaking to do as well as possible, how to be compliant as hell, as do everything they can to comply with the hurdles that they have to take. But so far, for the broad economy, for the broad practice, I haven't actually come across a scenario that works for pretty much everyone and poses a solid, stable basis for data export to, let's say, the US. And so, which leads me to my next question: how are the authorities dealing with all this? I mean, if it's so difficult, do they not know? What do they do? Like, do they fine people? Do they issue fines? Do they help? Do they accept? Do they do nothing? What do they do? If it's so obviously illegal, and obviously the supervisory authorities can read Court of Justice rulings, what do they do? In Germany alone, there are many supervisory authorities because Germany, and that's an exception in the EU, I think along with Belgium, has one for each state, like as in federal state. So we have, I always forget if we have 16 or 17 states in Germany, I'm sorry. So we have that number plus 2 because Bavaria has 2, and we have a federal one too. So, and how is everyone in Europe dealing with this? The answer is it varies. I've read all sorts of opinions from stop it now to silence. So it really depends on what jurisdiction you're in or under, what supervisory authority is competent for you. And so what we data protection people did, obviously, was going out and listening to speeches that the authorities would give, saying how they want to handle things. And I won't go into detail. The common denominator is, let's not find the controllers and processors who are trying their best. They know the problem exists. And in many instances, they don't have any better solutions as well, either. They really just sit there and have the same problem. They give recommendations. A lot of authorities give you download resources on how to deal with this and that, and if you supplementary measures and that you might use or might not use. But the broad denominator is, if otherwise companies are doing okay, then let's not go out and fight a war that they cannot win, and that is not going to change anything in the long run. Most of them, for at least I haven't come across proceedings for a fine that they would issue purely on the use of a US cloud service. So basically, and this is, I'm not guaranteeing you that it will stay like this, but mainly what I have come across is that they basically wait for further notice from, let's say, the EU Commission or the courts, or sitting tight, or until they need to do something. There are some proceedings that they legally have to initiate. For example, if they receive a lot of complaints from data subjects, in that case they are kind of obliged to do something to initiate proceedings. But even if that happens, they might just ask a company what they do with personal data, or what supplementary measures they have taken. But it's basically, let's not issue fines to companies that are doing their best. What they basically do is they do audits and fines only if they find something else, like if they have a reason to believe that on top of the cross-border data transmission or processing stuff happens. In that case, they will become active and do whatever they can or want to do. But that means usually in practice, if they initiate proceedings and audit, there's usually something to find. I mean, from a data protection officer standpoint, I can say, if you audit a company in data protection resources deeply enough, there will always be something you find. However critical it is, but it's, I don't know if some of you remember their military service when you had to clean up your room and then your boss came in. I don't even know the military term for boss. Came in and they used their finger to find dust somewhere. It's like that. When you audit data protection things with a company, you can always find something if you want. And a data protection breach hardly comes alone. If you find something, it doesn't have to do with cross-border data processing, but if you find something, then you usually find several breaches, because it usually the fish starts stinking at the head. So if you find something, it's usually the result of bad documentation or bad setup of something, and then you will be able to find more if you want. So it's not like supervisory authorities can do nothing. They can, but from my understanding, they're trying to move companies away from, especially US providers, to provide an alternative and say, hey, why don't you use a different Office suite instead of Microsoft 365? Or why don't you turn additional services in Microsoft 365 off? Or why don't you? So even though Schrems 2 is now almost 2 years old, I have not come across a fine, at least a respectable, a substantial fine issued towards a company that did nothing wrong apart from hiring a US-based processor. I just haven't. They might be out there. Also keep in mind that issued fines are not always public, and there is actually a long argument out there on whether they should be, because they can cause additional damage and all, but they might be out there. I just don't know about them yet. So to summarize all this, it's kind of a, everyone knows about the conflict, and nobody has an actual solid solution for the broad masses. And this is what it is for now. Let's go on. This is going to be good. The EU's current attempt to solve the problem. So if we know we have a problem, all the companies do, what can they do? And even whatever they do, in most cases, doesn't actually solve the problem. It might alleviate the suffering, but not solve the problem. Then the EU has a new idea, apparently. Let's remember our options. We have two options. Again, an adequacy decision. I said that currently we don't, but there might be, maybe, again, in the future. And appropriate safeguards, the new SCCs that everyone's using currently. Then what about we make a new safe harbor or privacy shield or data protection haven, data privacy bay, privacy compliance, something thing? Couldn't that help? I'm not making this up. The White House, at least, and it seems to be official, the White House issued in late March, so it's about a month old now, not even, issued a press statement saying the United States and the European Commission have committed to a new transatlantic data privacy framework, which will foster transatlantic data flows and address the concerns raised by the Court of Justice when it struck down in 2020, and so forth and so forth. Just so you know, for now, there is no actual draft or official text that could have been analyzed, so we're just guessing. But one thing is for sure, TADPF is coming to a cinema near you. TADPF. It's everyone. A lot of people are actually making fun of this. What does this mean? Can this solve the problem? What is it going to be? Again, there's nothing I can analyze for you at this point, but it's the future is not looking too bright. Why? The underlying problem is that we need to get beyond the mind problem. So far, we're trying, like the EU has passed the GDPR. Fine. The GDPR now reaches out to the US and to the entire world, basically, if you want to transfer personal data somewhere else and have it processed there or process it there. So there are tons of things that we need to do. You remember, you endured my speech until here, so you know it's a problem. The supplementary measures are a problem. And so the GDPR is basically enforcing rules in the entire world, if you will, not all at once, but so it's reaching out saying, like, you have to abide by my rules. And then conversely, the other countries obviously have national laws that force companies like AWS or YouTube or Google or Facebook and yada yada to give access to personal data that the GDPR says you have to protect. So, and this might be something you remember from your childhood. Maybe it's a German thing, I don't know. This is Ballerburg. It was a game in the 80s where you basically shot at each other all the time, and you had to like put your cannons up and down and shot at each other, and you had to kill the king basically. And to me, in a way, what the EU and the US are currently doing is exactly that. They're shooting laws at each other, and everyone says, oh, your law, I can't deal with it. The EU says, oh, you US, you have to protect personal data and the rights and freedoms of everyone involved. Whereas the US says, oh, but you, Europe, you of course, terrorism has to be fought. So I request data from my companies who are subdued under the U.S. legislation. So, and they're basically shooting at each other all the time. And while all this happened, when the TADPF press release came out, it felt to me like this. In our team data protection, we were sitting in our little offices weeping and wishing for our lives to end. Whereas the EU Commission basically just said, hey, let's create a new safe harbor privacy shield thingy. And I might be making more fun of this than I should. And again, there is no actual draft out there that could be analyzed yet. But I can tell you that there's one person in Austria that went like, oh, dear Lord. Yes, Max, I feel you. I really do. But and how do I know? Because we don't know each other personally yet. But how do I know that he feels like that? You can read it in subtext. I promised you that I would link his organization NOIB, which is an acronym for None of Your Business.eu, deals with privacy matters up and down. And they have released a statement on this. It's obviously a first statement, and they also say there is no draft of the TADPF out yet. But so until now, no ways have been announced to overcome the hurdles that have always been there with Safe Harbor, with Privacy Shield, the hurdles that I mentioned in this talk again and again, that you as a data subject can't go to court, you can't enforce access to your data, not even that, let alone erasure, correction, all sorts of things. And so far, there are no measures on the horizon yet that even allude to the possibility that TADPF might be anything else than, essentially else than Safe Harbor or Privacy Shield. And allegedly, they say, I can't confirm, I have no knowledge of that. If you do, let me know. Allegedly, the U.S. surveillance laws aren't changing. I mean, not for the better. They might be changing, but like towards more access to more data. But exactly U.S. surveillance is a critical threat to the principles that the Court of Justice in the EU took as a reason to invalidate the two previous adequacy decisions of the EU Commission. So, and they basically say, if TADPF is not in line with EU law, we or another group will likely challenge it. In the end, the Court of Justice will decide a third time. And I mean, with Max, you can really be sure that this is not just an empty warning. He's done it before. He knows how to do it. I think after the first one, when Privacy Shield came up, Max allegedly said, "Oh, can someone else do it this time?" But he's really good at it, and why not send him again? So I'm sure they won't hesitate to go to court a third time. So if TADF comes, a lot of companies, I'm sure, will submit themselves to that, but for how long will that be a solution? So let's come to the conclusion. Let's conclude the current status. There has not been a set of rules that the EU Commission has approved of that has held up with the US, meaning data processing in the US, because of the lack of effective data subject rights. Remember, they can't go to court, and that is the one essential problem. And also, by now, you have probably understood that no matter what two parties in this context conclude contractually, meaning what they agree on, you and Amazon Web Services, you and Google and another third country processor, whoever, whatever you two agree cannot solve the actual problem. The problem is that the laws give or take certain rights, and no inter partes contract can do that. You and I cannot contractually agree on certain laws not applying anymore. We can do our best to circumvent it or take measures that you wouldn't be able to give access to personal data. But if I give you data that you can process and access and pass on, transmit, give access to, then there's nothing really that we can do to solve the actual problem. The effective measures render most services useless in practice, meaning if you as Amazon Web Services cannot access data, then you are a provider of storage space for encrypted backups. Okay, let's assume the encryption is good enough for Amazon Web Service not be able to hack it, which is an entirely different discussion. But let's just say we have that covered. If I want a cloud service, most of the time I want the service provider to work with my data, otherwise it's useless. And on the contrary, the ineffective measures, meaning all the, like, give me reports, you can tell me that you have made certain data accessible to an authority, are more or less useless because they're not solving the problem. And so far, or at least currently, and I don't know, the good companies, the bad one, bad in this context means they just don't care. If you just ignore everything, then of course you just ignore it. You're not compliant. Anything could happen, risks, whatever. But even the good companies have adopted time and time again for Safe Harbor, for Privacy Shield, and are probably going to do the same for TADF if it comes again, adopted to each new standard set of rules and still find them uncertain about whether they're doing things right, if there's something else that they could be doing. And really, the supervisory authorities are super, super busy. They're swamped with work. So if you think, well, why don't we as a company just ask our competent supervisory authority if a certain set of supplementary measures is sufficient, let's say it is not very likely that that's going to work out. Yes, supervisory authorities are supposed to help and consult and help you, but they're hopelessly understaffed in most cases, at least still. That might change in the future, but they're not going to help you in your specific case. And I've heard of cases where they have been approached to evaluate a certain thing and then basically said, oh, okay, if you're really uncertain about that, why don't I come and check you entirely, audit you, and let's just see what comes out. So there is I would say, natural hesitation that most companies have to approach a supervisory authority, no matter how much their leaders say that they're very approachable and they're obviously happy to help. So even the good companies in this context are doing their best, but there is, in my humble opinion, no broadly practicable solution out there that will make you 100% compliant if you want to process personal data, let's say in the US. Just there isn't. And one little more aspect I'd like to throw in, because I'm using my conclusion to do this. Ask yourself this. We're talking about the bad US for all the time here, but it would be like similar with, I don't know, Russia, China, whatever you want. Let's assume for a second Germany wasn't in the EU, but let's say you're a controller in, let's say, Spain, and Germany isn't in the EU anymore. Let's say Dexit happens and Germany gets out and stuff. Hasn't happened with Germany, and I hope it doesn't. I truly do. But let's just assume for a second Germany is not in the EU anymore. Would Germany be a country with adequate data protection levels? I mean, GDPR adequate. And let's say you don't have an adequacy decision from the EU Commission yet. Would Germany provide an actual adequate data protection level? Let's have a look. To assess this, the hurdles are in Article 45, number 2, and in letter A. And I'm just roughly summarizing. There's tons of arguments about this among experts, and I'm just saying it's questionable. The law says important is the rule of law, respect for human rights and fundamental freedoms, and I would think you could say yes to that for Germany, as well as effective and enforceable data subject rights and effective administrative and judicial redress for data subjects. This is exactly the term, exactly the clause that is problematic with many countries outside the EEA. But how is it with Germany? Does Germany have effective and enforceable data subject rights and effective administrative and judicial redress for data subjects? For, again, authorities requesting access to personal data, for example, the Bundesnachrichtendienst, secret services, things like that. Can you get access to your data from the Secret Service, the Bundesnachrichtendienst? I'm not an expert on this, but I think the answer to that is no. Why? Because the activities that the German secret services, the German authorities get, the processing of data that they do in their daily work, sometimes and in many cases doesn't even fall under the GDPR. So in Article 2, it's just excluded. And it's unlikely that there are any adequate substitution rights. So if you want me to show you this, let's just have a look at it. Article 2. So here it is, this regulation does not apply to the processing of personal data by the member states when carrying out activities which fall under the scope of Chapter 2 of Title 5 of the Treaty of the European Union. And that is, let's say it's a little hidden, but what that means is basically everything crime-related. So if we want to ensure federal safety, things like that, there are tons of things that are excluded. A criminal prosecution, I think, is a different clause, but criminal prosecution is involves personal data, and that is for repression measures. When the district attorney processes data, that is beside the GDPR most of the time. So it's very questionable if what I'm saying is it's very questionable whether you would even get access to your own personal data. Yes, the certain criminal authorities have been successfully sued for revelation of data, but not personal data under the GDPR, but let's say budget decisions and decisions that had nothing to do with single natural persons. So what I'm saying here is it's very questionable whether even Germany would provide adequate levels of data protection if it wasn't a EU member state. It's just that Germany is already a member state. The focus, the scope of examination is different for everyone in the EEA. So in a way, you're comparing apples with pears. It's very odd, I think. So, okay, so what can we do about all this? I think as long as the EU and especially the US play Ballerburg, meaning they impose their respective laws onto each other, there cannot be a sustainable way to process data in the US. I just think there can't. I haven't seen a viable option. I see two options for this to go away, for this problem to go away. One option is the US get rid of their laws, like lower their terrorism fighting standards and all the laws that grant access to data worldwide, no matter, just because the companies that they're requesting it from fall under their jurisdiction. And yeah, that's not going to happen. Or option two is the EU Commission lowers the GDPR standards on cross-border data processing. Just says, well, okay, if we put this, if you want to process it in the States, you're okay. And that's not going to happen either. It's just not. It's very odd. And to me, honestly, seeing the EU now coming up with a TADP that is, at least there is no signal yet out there. If there were, I'd be glad. That doesn't seem to change the underlying problem, solve the underlying problem of enforceable data subject rights. To me, the EU looks like this. That's what they do. Like anytime Max goes to court, Max shits on them. They just wipe it away and go, okay, let's go again. Let's go again. Let's go again. It is very odd, I can tell you that. But so I hope that you've learned a little bit about why it's so difficult for data protection to be territorially expanded onto the world and why all that is so difficult. Everything that's left for me to say is thank you for watching my seminar. Thank you everyone in the organizing teams across the globe for organizing the satellite parties, the core organization team for Revision Online 2022. You watching, if you have questions, approach me, please. Things and everything, you know. And thank you again to Gizmo for providing the amazing background video that you've been seeing in the background all the time. Thank you to Hubert for lending me his amazing camera. I feel like I'm in a TV studio. It's quite amazing, I think. And so if you're interested in this presentation that you have just seen, then you can download it here. And I think that concludes my seminar for you. I should have been available in the chat, but approach me on Discord if you want, if you just have follow-up questions. I'm happy to answer all of this. And again, I hope in the very near future we will have an Ask Me Anything related session where you can toss all your audio production, copyright questions, GEMA questions at me. And let's have an amazing revision this year again. But I truly, truly, truly hope that we can meet each other again in person. I really want to give you a hug at this time. I really do. Thanks, and have a good day, everyone.